The broadcast is now starting. All attendees are in listen-only mode.
Hi, good morning everybody, and welcome to the webinar, Getting the Principles Right. This is obviously, I was saying, in the 3 years that I've been with Storagecraft, this is the highest number of attendees I have seen for a webinar. So it obviously smacks of the level of interest that there is in this topic. So while people are just coming on board, I'll just tell you a little bit about the format, what we're going to have today. So as I say, this webinar is sponsored jointly by ourselves, Storagecraft, and by RapidFire Tools. So I'm going to take a couple of minutes to just tell you a little bit about Storagecraft and our products. And then I'm going to hand over to Tara Newman from RapidFire Tools. She's going to take just 2 minutes as well to tell you a bit about their products. And then we're going to hand it over to Gary Hibberd from Agency, who is our expert for the day. And he's going to sort of do a little bit of a presentation. But really, I suppose the value here is the questions that you guys have. I would say to people, get your questions in early, because I'm expecting a lot of questions, and we want to be sure that we get to them as many of them as we possibly can. All right. So thank you all for telling me that you can see my screen and that you can hear me now. So we shall go onward. Okay. So Storagecraft, and I know a lot of you are familiar with Storagecraft, so I'm not going to dwell too much about it. Basically, company, we've been going since 2003. We've got global offices from in the US, Asia, and I'm speaking to you from our EMEA headquarters here in Cork. We're a 100% channel company, and we currently we have about approximately 11,000 global partners, but that number is growing. We've had some recent acquisitions, and what all of this really says is that we're a company that's growing, and we're very proud of the fact. We've worked with a lot of leading brands, which you're seeing there on your screens, and we've enjoyed success across a whole range of verticals, which you can see there, and you'll see some very well-known, high-profile brands there as well. But what do we actually do? Well, our mission, or our promise, if you like, is that with Storagecraft, your data is always going to be safe, it's always going to be accessible, and it's always going to be optimized. And how we deliver on that is essentially the data protection and keeping your data safe is something that I suppose this is what we built the company on, our disaster recovery suite of products. What all of this means really is that we deliver disaster recovery tools which allow you, service providers, to go ahead and offer disaster recovery as a service and to protect the information of your clients. To the second part and the third part of what our promise to you is about optimizing data and making data accessible. This is a sort of a new venture for us, and it's been very successful so far. And it's built around this scale-out storage solution, which allows a company where you can predict the amount of data that you have, and data is growing rapidly. This gives you a scale-out solution. Now, we know scale-out is not necessarily a new concept, but it has always been sort of the preserve of the enterprise clients. And what our aim is to bring that scale-out solution and those enterprise features like inline deduplication and compression, to make those accessible to the more mid-market enterprise. So in a nutshell, that's what we do. Now, after this webinar, we will take the time to send you out a little bit more information about our products. So with that view, I am now going to hand over to Tara, so she can give you an overview of what they do. So bear with me while we do this. So Tara, have you?
Hi, everybody. Can everyone hear me okay?
Yes.
Well, thank you for attending. Thank you for answering. Thank you for attending today's webinar on GDPR. My name is Tara Newman, and I am the Director of International Sales and Marketing with RapidFire Tools. Some of you may know, and others may not, that RapidFire Tools got its start as an MSP over 10 years ago. We are the market leader in IT and compliance assessment software, and we only sell to the MSP and VAR communities, and never directly to your end users. We take our job of making your success very seriously. So what does RapidFire Tools do? We specialize in 3 core things: agentless and non-intrusive IT assessments made fast and easy, internal cybersecurity, meaning the monitoring and alerting of risky human behavior that takes place behind a firewall, behind an antivirus, and comprehensive compliance reporting and documentation. Those 3 things fall into 3 product categories: Network Detective, the #1 IT assessment tool on the market for MSPs, Detector SDS for internal threat detection, and announcing here today, Audit Guru, which will take what we do now in regards to compliance reporting and upgrade it to an ongoing solution that will help you prove best efforts towards compliance. And the first regulation we've decided to tackle with Audit Guru is the General Data Protection Regulation, aka GDPR, which is perfect because today we are going to be talking a lot about GDPR. This compliance standard, as I think most of you know, was introduced in 2016 and was designed to create a standard methodology to protecting and keeping personal information private. We have developed Audit Guru as an assessment, reporting, and documentation tool that will allow you to help your clients show best efforts towards this compliance standard. It's set to come out in early Q1 of next year, and AG GDPR is going to act as your compliance officer in a box. On the screen now, you can see a list of reports that we are planning to include with Audit Guru GDPR, and we have done the work to become GDPR experts, so you don't have to incur that heavy overhead cost. Along with the reports and documentation on the screen, the solution is also going to be automatically scanning your networks and computers and looking for information relevant to GDPR compliance. It's going to be performing internal audits. It's going to produce all of this documentation, uncover GDPR-related issues, and document and track the remediation of them. And if you're using popular PSAs like Autotask and ConnectWise, you're going to be automatically able to take those issues that we find and turn them into tickets to get your technicians working on them right away. All of this and much more, if you're interested in finding out more about the product, please visit rapidfiretools.com/GDPR and sign up today. Those that do will get advanced product updates and a special introductory offer prior to the release. But first, I have on the phone Gary Hibberd. Gary has 32 years of experience in the IT industry and is the Managing Director of Agency, an international cybersecurity consultancy. Gary is an expert in GDPR and has become a renowned, experienced practitioner on the subject. Gary is going to talk to us today about the principles and requirements of GDPR, and I know Jen and I are very excited that all of you could join us today to listen to him. By the end of the webinar, you will have 4 things that you can take away and do immediately to start getting ready for GDPR. All right, Gary, I am going to give you presentation control now.
Thank you.
And thank you, everybody, for coming out.
Thank you. Good morning, everybody. Hopefully you can all see my screen now, which should be the standard color that most of us would be used to seeing when we're talking about the General Data Protection Regulations. My name, as Janet and Tara said, is Gary Hibberd. I'm the Managing Director of Agency, and I'm not going to go into too much about who Agency are or what they do. They will be my email address will be on most of the slides. You can Google the organization, you can find out a little bit about us. The principal purpose for this session, of course, is to talk about GDPR, and we are going to get into some of the detail of this new regulation. We're going to talk about the principles in quite a bit of depth. So this webinar is a little bit different to my usual kinds of presentations, where I just simply have pictures and such like. There will be quite a lot of detail, but that's intentional to hopefully give you enough information and things for us to discuss, but also make sure that you have an opportunity to ask questions as well. If you do have any questions, please feel free just to ask the questions, and Janet or Tara will interrupt me as we go if it's relevant at that point, if I'm not making myself clear. But certainly at the end, we will have an opportunity for questions.
Gary, can I
yes?
Can I just jump in there? If you could minimize your the console, which is yes, if you go.
Okay, can I just move it down there? Is that okay?
That's perfect. Okay.
Excellent. Okay. So we have a technical problem right from the word go, so that's fine. But one of the things I will say before we get into the actual presentation itself is that I am a GDPR specialist. I describe myself as such. I typically avoid the word expert personally because GDPR is yet to be in place. It's yet to be tried and tested. So in actual fact, we are all in some respects learning GDPR as we go. So there's certain things around GDPR that are yet to be cast in stone. So it's important to say that at the outset that whilst we can be certain about certain aspects of the regulation, there is certainly much yet to be confirmed. I would also urge you, whilst we are focusing very much on GDPR, if you are involved in the marketing world, you should be aware of other regulations, and one in particular, which is known as PECR, P-E-C-R, which is the Privacy and Electronic Communication Regulation. So there are other regulations that will have an impact upon GDPR, which you should be aware of. So I'm always at pains to mention that right at the front before we get into GDPR, which I know and I appreciate you're all here to talk about. So what are we going to talk about today? What's our agenda over the next 30 minutes? We're going to discuss what is the GDPR in detail. We're going to really get into the principles, the real devil of the detail. And as Tara said, we're going to give you at the end of this at least 4 things that you should be taking away with you. Feel free to take notes as we go, but certainly at the end there will be slides that you will be able to see some direction, and you'll be able to have access to these slides thereafter. And as I already mentioned, my contact details are at the bottom of the slides as we go. So first and foremost, what is the GDPR? Well, as the presentation dictates, this is the General Data Protection Regulation. It's a new regulation that was born really out of necessity in 2012, in as much as the EU wanted to unify many different regulations and approach to data protection across the EU, and started to work on a uniformed approach. So we are in 2017 now. This has already been in place for well over a year. We had 2 years of transition. So in May next year, we should be all ready to have this in place and to be enforced. So I'm sure most of you are en route to doing that. But when people say to me, Gary, what is the GDPR? What is the General Data Protection Regulation? I simply say, look, if you're having difficulty remembering what those 4 letters stand for, simply think of it in this way. It's about giving data proper respect. For far too long, organizations have, large and small, have almost ignored some of the requirements under GDPR. Me personally, I get quite frustrated when I talk to people and they don't have a basic grasp of just essential data protection rules or regulations, or understanding of what the rights and wrongs of the way that they treat data. And I think for far too long, we have ignored some of the basic things that we should be doing to protect information. The ICO and the EU obviously agreed with that, and that's the reason why we have GDPR coming into force next May. terms of this being a EU regulation, what we need to remember is that yes, it is an EU regulation, but it is very specific in as much as this is about EU citizens. And whilst we may just pause for a second, within the UK, of course, many people may ask themselves, is this relevant to us because of Brexit? Well, in the UK, just to be clear, we have the data protection bill that will be in force way before the 25th of May next year. It's going through Parliament as we speak and is thought to be, will be in place round about February, March next year. So that data protection bill will enshrine what GDPR is aiming to do, and it will enshrine that within the UK law. So even though we may think of this as an EU GDPR, this is very much about making sure that we focus on UK citizens as well as European citizens. So if you are an international organization and you deal with the EU, if you have employees who are EU citizens, then this applies to you just as much as it does to any organization that is domiciled within the EU itself. So how big is this? Well, the Information Commissioner's Office has stated this is a dramatic change in the way that we think about data, in actual fact. But it shouldn't be revolutionary. This is evolutionary. So whilst we may hear about, and we will talk about fines, we shouldn't be fearing GDPR. We should be seeing this as a positive opportunity to look at our organizations and the way that we use data and the way that we keep it safe and accessible and optimized. Everything that Janet mentioned at the outset there, where we talk about how we ensure we keep information safe, that's what GDPR is all about. So it shouldn't be seen as a negative. But the ICO themselves, Elizabeth Denham, who is the UK Information Commissioner, has stated, you know, there's a lot in GDPR that we'll recognise from the current Data Protection Act, but this one is a game changer for everyone, because she went on to talk about the fact that it's going to be it may be a fundamental way of rethinking how we think about data. And I often say to organizations that we should think about data in much the same way that we think about food. And it's how we consume that food, it's how we consume that data, and what are we doing with it? How long are we holding on to it? Are we a data healthy organization, or are we suffering from information obesity? And the problem is that, as you can see here, that three-quarters of us don't trust businesses to do the right things with our emails, phone numbers, preferences, and bank details. And like Elizabeth Denham, I'm quite shocked by that, but not surprised, unfortunately. So what I would say about GDPR is, before we get into the devil of the detail, is just to remind you that this is a good opportunity to help you demonstrate that you're a trustworthy organization and that you're doing the right things with people's data, that you understand their needs and you're putting their security and their safety before the needs of your own organization. I see that as only a positive thing. And if we approach it in that way, it will be a benefit to your business, not a drain on your organization. So what are the headlines? What are the key things that you need to know? Well, the headlines for me are very simple. It comes into force immediately on the 25th of May next year. It absolutely applies to every organization, irrespective of your size or sector. So I often have organizations say to me, Gary, we're just 5 people in a room. Surely this doesn't apply to me, or we're less than 250 employees. This doesn't apply to me. Well, in actual fact, it does. And the reason for that is quite simply that we are all capable of amassing and storing and using, and unfortunately losing, large quantities of information. So the ICO, the GDPR, has not stipulated anything in terms of whether this applies to you as a large organization or a small organization. Yes, it expects you to apply rules and the regulations appropriately to your size of organization, but it's not saying that you can ignore it. Some of the other headlines that we hear about quite often are things such as the ICO must be informed of a data breach within 72 hours. And I will caveat that by saying you need to make an assessment whether the ICO needs to be aware of the breach. And there are certain rules within the regulation that state whether you should or shouldn't. I always say the key thing here is, would you understand what to do if you did have a breach, and who would need to be informed, and how you would do that communication. Another area that we hear about quite often is that all organizations have to have a data protection officer, when in actual fact that's not true. There are a number of reasons why you would need to have a data protection officer within your organization, but you should still assess that need. And I would always advocate having somebody who is responsible for data protection, whether you call them a data protection officer or not. So look around your organization, take that question away with you to your boards and say, who in this organization is responsible for data protection? Of course, we have new rights within the regulation itself, the right to be forgotten, which we'll talk about in a little while, and we have other things such as fundamental changes, such as the charges for subject access requests has been removed. Most of the organizations charge a small fee. That has been largely removed now, unless there is a substantial cost to you for providing that information. And some of the final headlines there: privacy by design and default. If you're an organization that develops solutions and systems, then you need to think about how you are ensuring that security is part and parcel of everything you do, almost at the heart of what you do. And that means performing some form of protection impact assessments. How will the protection or non-protection of information impact upon individuals? And the final part here, and this is the where we're going to get into more detail in a few moments, there are 6 principles focused on accountability, and some people actually refer to accountability as almost the 7th principle. It is that important. So ensuring that someone is accountable in your organization is really key. Now, it would be remiss of me not to talk about the fines. I don't like to get fixated on them because yes, they are large, but I think most presentations on GDPR will at some point talk about fines. So I will venture into that with you right now. And of course, we've all heard about the penalties that could be up to 2% of your annual turnover, or up to 10 million euros, depending upon the offence that is carried out. And of course, much larger fines of really severe breaches of the data protection regulations could be up to 4% of your turnover, or up to 20 million euros. So these are quite scary numbers, of course, and they are things that we should be very much aware of, but I don't see this as should be our key focus. And the reason for that is that, well, when we think about the penalties themselves, Article 83 actually states quite clearly that fines will be levied in dependence upon the nature and gravity of the infringement. What actions were taken by the controller or processor to mitigate the damage suffered by data subjects, and what was the intentional or negligent character of the infringement. So consider this for a second, that whilst many people are fixated on the fines, thinking, well, you're either in one of two camps. You either fear the fines and you're running scared of them, or you're of the second camp, which will be, well, they'll never come and fine us. It's ridiculous to think that we will get fined that sorts of money. I simply say to you is this: fines will undoubtedly come. Will they be up to the 20 million euros? Who knows? But if you can demonstrate quite clearly that you have done all you can, that you have taken appropriate steps to protect the information and the data subjects, and being aware of the risks and have put in appropriate risk mitigation tools and techniques, then it is highly unlikely that you are going to be hit by these humongous fines that we keep hearing about. So yes, of course, be conscious of them, but don't fixate upon them. See GDPR as a positive, see it as a way to understand what your data looks like and how you're protecting it, and ensure that you don't have an intentional or negligent character of the infringement enforced against you. So in terms of GDPR itself, what is it trying to do? Well, of course, it's trying to protect personal information. We're actually thinking about personal data. It's important for us to all be very clear on what is personal data. And under Article 4, the very first meaningful, if you like, article for me under GDPR in terms of explaining what some key terms are, the very first definition it provides is on what it means by personal data. And you can see there that personal data simply means any information relating to an identified or identifiable natural person, herein known as the data subject. So it's an identifiable natural person who can be identified directly or indirectly by any identifier such as a name, identification number, and so on and so on. So you can see here it is extremely broad. And if you think about your organization, you think about the data that you hold, if you understand what that data is, you will know whether you are actually holding personal data and how much of that could almost be classed as sensitive information. So if we are talking about information which is regarding your sexual orientation, for instance, or medical information, or if it's to do with trade unions, for instance, or your ethnic background or your religious beliefs, this would be considered as a sensitive information, would need a higher level of security perhaps. But certainly from the outset, we are looking to protect personal data. And when people say to me, is GDPR important? I always emphasize to them that this is talking about them as individuals as well. So organizations across the land are now having to look at their own methods of protecting data, and that data is talking about you and I. So it is extremely important, and it's how they're processing that data that GDPR is trying to understand and ensure that it's being managed in an appropriate and secure way. But what it is processing? Well, again, we turn to the GDPR, and processing simply means any operation or set of operations which is performed on personal data or sets of personal data, by whether it's automated or not, whether it's the collection, recording, organization, structuring, storage, and so on and so on. Pretty much anything that you do with data, personal data, would come under the definition of processing. We are all data processors in one way, shape or form. Of course, there's another definition which we don't go into too much detail here, but you also have to ensure that you understand whether you are a processor or whether you are a data controller. And understanding what that relationship is, again, will determine some of the key actions that you need to perform a little bit later. So in terms of GDPR, I'm sure we have many people who are on this webinar now, and I'm sure many of you have read the regulation. But I'm also going to say that I'm sure many people out there haven't actually read the regulation itself either. So if you haven't read the regulation, here's just a snapshot of what it looks like. This is the whole thing, if you like. There are 9 chapters. There's 99 articles. There's, if you're interested in reading it, it's 261 pages. There's 55,046 words. So it's not a very long read by some standards, but it actually is not that difficult a read anyway. If you are wanting to understand what to do with general data protection regulations, I would urge you to read the actual regulation. So, and if you are going to read it, I can give you a bit of a cheat sheet. You should start at the principles, which is Article 5 to 11, which is what we're going to go through in a few moments. But essentially, the regulation itself is very far-reaching. There's a lot to it, but we are going to focus on purely on the principles right now. And the principles are quite simple, really, in real terms. There are 6 principles. Currently under the Data Protection Act within the UK, there are 8 principles. So this has been reduced to just 6. And these are the principles that you need to think about within your organization. Are we processing data lawfully, fairly, and in a transparent manner? And so on and so on. And these are the processes, these are the principles rather, that we are going to look at in a little bit more detail now. But if there's one thing that I would urge you to do is to look at each one of those principles as it appears to you on screen now and ask yourself, can your organization demonstrate that it has evidence towards compliance on those particular areas? And that's what we're going to go through within the next few moments. So, what do we actually mean by something being lawful, fair, and transparent? Oh, apologies. This is the 7th principle I talk about quite regularly, which is the principle of accountability. So it's important just to again remember that this is at the heart of GDPR itself. So lawful, fair, and transparent. The principle speaks to us and says that it will be processed lawfully, fairly, and in a transparent manner in relation to the data subject, and that processing will only be lawful if you have permission to use that data or to process that data on behalf of the subject. And as you can see here, there are several reasons why you may want to or be able to process data. And the first one, data subject gives consent for one or more specific purposes. And we will return to consent in a few moments because it is such a big area and one that is causing much confusion around Europe and beyond. What I would simply say to you is this, is you need to have a clear understanding of why you are processing data. Ask yourself why you are holding that information. Do you need to hold it? And if you do you have a lawful basis? And can you demonstrate what that is? And it could be for contractual obligations. That could be if you are selling a car, or if you are if you are a law firm, or if you are an accountant, and you need to collect information from them. There will be a contract between you that states these are the reasons why I need to hold this information. You are not seeking their consent for them to give you information for you in order for you to do a job for them. It's also obviously from a legal obligation perspective. So again, a good example, if you are a financial institution, you are collecting information from individuals because you may need to do credit reference checks. You may need to make sure that they are credit worthy, and that's in their interests as well. So there's a legal obligation placed upon you to collect that information. It could be in their interest as well, if it's the vital interest of that individual. And of course, it could be in the public's interest. So quite often people talk about their rights to be forgotten. Well, you don't have a right to be forgotten if you are for instance, a government body who are holding information about somebody's law infringements. So you can't go to the police and say, please forget about everything that I've done wrong. So it's in the public interest that we hold that information. And of course, it could be a legitimate interest by the controller. So it could be marketing, could be a legitimate interest. And that comes on to the consent in actual fact. We'll come back to what this means to you in a few moments when we come to the end. But when we talk about conditions for consent, for the following conditions apply for consent, controllers must be able to demonstrate that consent was given. So if you are marketing, if you are a marketing organization, this is going to be something that will be particularly of interest to you. So you need to be able to demonstrate that you have obtained consent, that it was clearly given and it was intelligible. But it also must be easy to withdraw that at any time also. And please make sure that you are now starting to assess your controls around obtaining consent. That is one of the key things that you need to be thinking about. And as I already mentioned, in terms of consent, there's a lot written about it. And under recital 47, the regulation, it says right at the bottom there that in actual fact, processing of personal data for direct marketing purposes may be regarded as carried out for legitimate interests. So please, if you're a marketing organization, don't fear GDPR and fear that you have to throw everything away. Certainly look at things like PECA or the new e-privacy directive when it comes into force next year, but there's other things for you to be concerned about rather than focusing or fixating too much on consent. So the next principle that we're going to look at here is the purpose limitation. This is that data will be collected for specified, explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. So why are you collecting the information? You have to inform an individual why you are collecting that information, and if you are going to inform them why, you cannot then begin to use it for other reasons. So make sure you're very clear about why you are holding information and what you're going to do with it. That's simple. So how can you be sure you're collecting the data for legitimate reasons and only for those reasons? Well, ask the business. Go back to your organizations and ask why you're holding that information. Data minimization, this is that personal data will be adequate, relevant and limited to what is necessary in relation to the purposes for which they are processed. This simply means that if you are a hotelier, for instance, it's perfectly acceptable perhaps to have my email address, my home address, my date of birth, but perhaps asking for my sexual orientation or what my last car was, or asking what my partner's name is or my children's name, that is certainly not why you would need that information. So it should be adequate, it should be relevant to the purpose that you are processing. So it is also important, of course, to understand how much data you hold, and again, you know, are you collecting just enough for the purpose of that processing? This, for me, is a fairly simple principle that data will be accurate and, where necessary, kept up to date, and that you should take every reasonable steps to ensure it is up to date and accurate. So, and if it is inaccurate, that you have processes in place to erase it or rectify it at the earliest opportunity. And it's, again, I come back to my point that I made right at the outset, which is these principles don't seem to me to be inappropriate for organizations to have in place. So I sometimes worry when organizations seem to be concerned about having to apply to GDPR principles, because I think that's a perfectly reasonable expectation of each and every one of us. The storage limitation that it should be kept in forms which permits identification of data subjects for no longer than is necessary. This article and this principle is speaking directly to organizations who are holding masses of information and with no good reason. So why are you holding on to information? Why are you storing, perhaps if you're a recruitment agency and you're storing information for far longer than you actually should be? If somebody comes for a job at your business and they are unsuccessful, is it right that you hold on to their CV for longer periods than is necessary? If somebody leaves your organization, are you holding on to ex-employees' data, employee data, their payroll information, their bank details? If you're holding on to that for unnecessary reasons, then you need to look at that very carefully. And again, when we talk about storage limitation, this is about holding on to information for as long as is necessary. It is down to you to determine what is necessary. Okay. So again, here, what this means to you is about developing your own data retention policies and assessing how information is being stored, where it's being stored, and for how long. And that includes archive and on backups and such. The final principle talks very much to my world, which is all about data protection and information security, and making sure that you can demonstrate that you are giving due regard to the safeguards of personal information of data subjects. So, as it states here, that this principle is about ensuring it is processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing. Now, it's an important point here. There's a couple of words that I'm going to highlight, which are just very simply appropriate security. So you don't have to do anything. There's lots of people out there selling on fear, uncertainty, and doubt. You don't have to go out, rush out and buy security dogs to protect your archives. You don't have to go out there and buy state-of-the-art biometric systems or encryption tools. They are purely risk mitigation tools and techniques. But it's talking about here is appropriate technical or organizational measures. If you're a small organization, it is appropriate for you to train your 10 or 15 staff on what is data protection. It would be appropriate for you to install the latest malware protection software, of course. It may be appropriate for larger organizations to look at things like ISO 27001, which we'll talk about in a few moments. So it's important to do that, but as a smaller organization, would you want to put something in place such as 27001, or maybe you want to look at some other standards like Cyber Essentials? What is appropriate to you? It is determined by you, but do something. ISO 27001 is quite complex, so this is quite a complex area, so I'm not going to go into any kind of detail, but it is a system that looks at people, premises, processes, and providers. So it does speak again directly to GDPR, but GDPR doesn't stipulate at all any kind of security standard that you should adopt, but certainly this would help you evidence. And there is a number of areas that speak directly to it. As I've already said several times, accountability is key. And we need to think about that because this is all about the protection of data subjects and the data subject's rights. I mentioned it earlier that there are a number of rights that data subjects have. And I think this is something that I would again urge you to take a look at your earliest opportunity. So when you are doing the audits that Tara mentioned earlier, that we're talking about, it's important to look at these areas and say, how can I demonstrate that we are able to ensure these rights are upheld? In terms of probably the key right, if you like, for me, it's about the Article 13 in terms of information and access to the personal information. The information is to be provided where personal data is collected from the data subject. So giving them the rights of access to their information is of key importance. So as it states here, and this is taken directly from the regulation, so if you read it, it tells you what to do. It simply tells you that when obtaining personal data, the controller shall provide the data subject with all of the following. It tells you exactly what you need to do. So again, and I keep repeating it, GDPR is not to be feared. It is seen as being almost a template and a tool to help you demonstrate that you are doing the right things with people's data. But the final part of my presentation, as was stated at the beginning, I'm here to give you some helpful advice and tips on what you should do. I have more than 4, so I'm going to very quickly just give you an idea of what you should be doing straight after this presentation, this webinar. And the first thing I would advise anyone to do is identify your data, because you cannot protect what you do not understand. So my tip for you is go away and create an information asset register at the very simplest levels, creating something that identifies what data you have, why you're holding it, the legal basis, where is it? Is it in the UK? Is it sat on a data center? Is it sat in a server? Where is your data? How is it being protected? And who has access to it? Answer those questions, and I promise you, your next set of questions will come. You can create structured questionnaires and have interviews, absolutely, but speak to your business, identify what data is there. It's of key importance. And once you understand what your data is, then of course you need to give it a good clean. This is an opportunity to have a spring clean of your data. I mentioned at the beginning about information obesity. So have a data retention policy. If you haven't got one, write one. Understand what data you have and why you're holding it, and whether you need to keep that information. Are we keeping it? Do we need it? Ask yourself those questions. And then understand how you can protect that data. Understanding how the data is protected, understand how strong access controls are to that data. Have you a backup of your data? Where is that backup data? Ask the difficult questions. And yes, absolutely consider encryption, but don't see encryption as being the mandatory control that many people talk about it as if it is. It is just one of many different opportunities or techniques that you can use to protect data. Question is why do you need access, and what are you going to do with that data? Make sure you're protecting it appropriately. And the final tips, if you like, are have a plan, build a plan on what to do when things go wrong, because undoubtedly things will go wrong. But hopefully many of you listening to this will have a business continuity plan that you can plug into, or an incident management plan. If you don't, then now's the time to write it. If you do, now's the time to review it. Ask yourselves, if you had a data breach today, would you know what to do? Would you know how to contact the ICO? Who would make that decision? Write it down, have telephone numbers to hand, useful links. What will we do when it goes wrong? That's a key question for you to go back to your board and ask. And of course, the final thing on this is, yes, absolutely. Consider standards. GDPR is not a standard. You are not going to get a certificate on the 25th of May 2018 saying that you have passed. You will simply need to demonstrate or evidence that you are making best efforts towards that compliancy. As we heard earlier, that's what all you can hope to do. If you want to implement a standard, then absolutely ISO 27001 will help. There are others, Cyber Essentials, business continuity standards, risk standards. There are different frameworks, but you should at least consider those things. Because when all's said and done, at the end of this, GDPR is absolutely closer than you think. It is actually 122 days away. And I mentioned it several times that I think of data into an organization as food is to me as a person. So it's a little bit like going on a diet. No one enjoys it. It's good and beneficial for our health. But if we think about the way that we consume data within our organizations, this is a cultural change. It's a shift in the way that we think about data. Ladies and gentlemen, that has been my presentation to you on GDPR and the principles. I hope those tips have been helpful. And I will now hand back to yourself, Janet, and hopefully that has been of use. Hopefully now, Janet, you will have that screen back.
Yeah, I've got you, Gary. Okay, so Gary, we have some questions coming in, and okay, so first of all, to anybody who's asked the question, yes, we will be sharing the presentation, and we will also be putting a copy of that webinar where you can reach it, and we'll do that within the next couple of days. Okay, so questions. The first question is, what business size by law requires a DPO, a data protection officer?
Okay. In actual fact, there is only 3 reasons why you would need a data protection officer. It's not to do with the size of the organization. And I'm always at pains to make sure that I quote these things verbatim. But if we look at the reasons why you would need to have a data protection officer. So, as I said, there's 3 reasons why you would need to have that. One of the reasons is that you would have, that you are a public authority, so that you are an organization that is a body, well, except for courts acting in their judicial capacity. The second is the core activities of the controller or the processor consist of processing operations which, by virtue of their nature, their scope, and or their purpose, require regular and systematic monitoring. And then the third is that the core activities of the controller or the processor consist of processing on a large scale of special categories of data. So it's nothing to do with the size of organization. So I like to quote the actual regulation there, because there is a lot of concern that in actual fact, I'm less than 250 people and therefore I don't need to do this. In actual fact, that's not not true, and that's quite often a mistake that people make.
Okay. So Gary, there's quite a few questions around consent.
Yeah.
The first
So
of
they might.
the first of those from Sarah is verbal consent valid, or do you have to have something in writing? And she gives the example for marketing purposes.
Yeah, you do have to have something in writing. So you have to be able to evidence. That's the key phrase. You must be able to evidence that consent has been given. So it'd be very difficult for somebody to be able to evidence that somebody said, yes, I give you consent. And again, it would be very difficult to be able to evidence that they have then revoked that consent. So you need to have some way of capturing that.
Okay.
And one thing I would say, and I know there's going to be lots of questions around consent, is that the ICO has stated themselves that there was a consultation paper on what consent means. The draft paper has been released, but the final paper has yet to be released. So we are all eagerly awaiting that to come through. But certainly consent is one of those areas which is causing most consternation for people. But you would need, absolutely, you need to be able to evidence consent has been given.
Right, and I suppose in the same topic again around consent, one of the questions is that if you only deal with businesses and we only deal with business contacts, does this category classify as personal data? And do the same rules apply in that business to business scenario?
Yeah, it does, and it's an interesting one. Again, if you read the regulation itself, it doesn't really, not within the GDPR, it doesn't really talk about B2B or B2C. Yes, there are other papers and guidelines around it that give advice specifically for different sectors and so on and so forth. GDPR does not make any differentiation between B2B or B2C. And a good example of that is where people talk about email addresses. So my email address has been on the bottom of all the slides there. By implication, I would like you to contact me and drop your emails to me, absolutely. But that is still my personal information. So my personal information there is being provided because in this day and age, ghibberd@theagency.com, I may use that email address to log onto eBay or onto Amazon or onto something else. So you can still identify me as a person from that email address. So the only time it doesn't apply from a B2B perspective would be if you were emailing sales@theagency.com. That's not personal information. Anybody, that could be anybody. But ghibberd@theagency.com is personal information.
Okay, so another consent question, Gary, and it's to do with sort of getting sort of retro consent. So if you're an organization, you have a lot of data that you've collected in the past. What do you do with that data that you've already collected? And do you now have to go back and obtain consent? Because the questioner says this could obviously be a huge task.
Yeah, absolutely. I think you need to be, again, in that respect, there's still lots of ground that's got to be agreed on that particular area. What I'm advising organizations to do is look at, I'm taking it on a case-by-case perspective. So I'm looking at, what was the consent given for? And has there been almost a, under PECA, so PECA is more sort of relevant to this conversation, to be perfectly honest. And the question is has there been an implied opt-in? So have they bought services, similar services in the past? Or would they be interested in continuing to receive those services? So in those situations, I would simply say I would be certainly going back to my client base and saying to them that rules are changing around regulations, and that we would like to continue to be in touch with them. So it's called re-permissioning, and I am advising people that that's a good thing to do, because again, it allows you to re-engage with your clients. And one particular company that I worked with recently, they had something like 30 or 40,000 people on their database, and they re-permissioned by going back to them and saying, we still like to be in touch with you. They reduced that by only about 10,000 people. So they had 30,000 plus people coming back to them and saying, yes, we would still like to talk to you. And they effectively have reduced their footprint, and now they have 30,000 people that they will actively want to be marketing and targeting.
So another question is, if our data is held in 365 or Autotask or QuickBooks Online, is the risk mitigated?
No. It's a simple answer to that. I mean, why would it? Because it's held in 365 and you're holding it with Microsoft and such. The question needs to be it still needs to be, where is that data being held? My question would be, who has access to that information? So, you know, I've seen it held, I've seen information with clients who have held data in very reputable and high profile systems, and everybody has the same password, everybody has the same logon details, and there is no control over access to that data, and anybody can access it and steal it. So from a technical perspective, you could suggest that some of your controls are being, or some of the requirements are being met in terms of the security, but it would be still a requirement for you to understand access controls, backup processes for that data, and again, sovereignty. Where does that data sit? So Microsoft, is it sat in America on American servers, or is it sitting in the UK? Where does your data sit? And you can stipulate that within the contracts that you sign with these large organizations, because they recognize they have to provide that service.
Okay. Next question. So the question is from the perspective of an MSP. Can you become liable for a customer's data?
Okay. Can you become liable for a customer's data? If a customer is a data controller and you are simply processing it, you are storing that data for them, then you are as liable as them if you do not have appropriate controls in place. So I would advise any MSPs, and we're working with several, to review the contracts that are in place at the moment with their clients to ensure that everybody is aware of the responsibilities. Under the current Data Protection Act, the role of the controller and the processor were quite different. I would say under GDPR, they've been brought more closely aligned, because it's recognized that it's very difficult for it could be that the processor themselves is under the control of the controller, but it'd be very easy for them to let down their guard and allow a breach to occur. The ICO has stated quite simply that if a breach occurs, they will decide at what level they will inform any kind of fine or kind of action that they may decide to take. So they will look at the situation, look at the infringement, and say, where do we think the blame is apportioned? Is it the controller or is it the processor?
Okay. There's another question from regarding an MSP, and I think you've answered that. So okay. Another question does GDPR cover employees of the company as well as the customer?
Absolutely. So you are, and this it's a great question, because, and I like this question because quite often I do get people say, well, we're a B2B, so GDPR doesn't apply. And my response to that is, well, first of all, yes, it does, because GDPR makes no point about B2B. And secondly, it applies because I assume the 300 people you've got sat out there aren't working for free. So I guess you collected their bank details off them at some point. You will have copies of their national insurance numbers. You will have perhaps their contact details for emergency. You will have information, obviously their bank sort code. You may have sickness and absence records, so you may have actually some sensitive data that you are holding on your systems. So absolutely, your employee data falls under this. So again, going back to tips and tricks, go back to each function and ask them what personal data they hold, and you may be just surprised how much information comes back from your HR department.
Okay. Another question on the DPO, and the question is regarding the DPO / compliance lead role. What would you class as conflicted roles in the organization, and he says particularly in an education environment?
Okay, so in terms of a conflict, again, very simply, you can't have somebody who is responsible for or involved with the process that you are managing, if you like. So again, under the GDPR, it starts at Article 37, where it talks about the designation of the DPO. So I would say conflicts of interest clearly would be people like your head of IT, your head of operations, your head of finance, those kinds of roles, your head of operations. These are people who, unfortunately, could, in the event of a data breach occurring, for their own self-interest, could try and hide the fact that a breach has occurred, or try and reduce, they may try and fix the problem before it becomes aware across the business. So ensuring it's probably easier to say what would not be a position that would be a conflict of interest, and those are people such as perhaps your audit team, your head of compliance, potentially head of information security if you have that role, or you have a designated data protection officer, or somebody who is responsible for all things such as your compliance. Yeah, so that would be probably a better way of thinking of it. But if anybody is involved in the actual process, then there could be a conflict of interest.
Okay. So the next question is, when providing a service to an organization through a contract, e.g. an IT support contract, can senior management of an organization provide consent on behalf of its employees in the context of the service?
Right, okay. It's difficult to, without knowing some of the context behind that, but I'm going to go out on a limb and simply say no. Consent, depending upon what the service is, of course. Unfortunately, I'm sounding like a lawyer now, but it genuinely does depend upon what that service is. Or, however, I would simply say that consent needs to be at the individual level. If you are using my data for whatever, for a particular reason, and it's in order, and you're doing that using consent as the legal basis, I think you have to think about what the organization is doing and how it's obtaining that consent. There could be other reasons why they are processing that data, and I would always urge anybody to look at the other reasons why you are processing data, what the legal basis is, other than consent. Consent for me is almost the last go-to place. There are probably other reasons why you're processing it. I hope that answered the question.
Okay, it's another consent question, Gary, and it's around if we purchase data for direct marketing purposes, do we get consent from the supplier? And in turn, does that mean that the supplier needs consent from all on the list? Correct.
Next question. No, no, absolutely. And again, under the recital 47, it talks about that direct marketing may, in capital letters, may be seen as legitimate interests. But if you are purchasing data, all I would simply say now is that you need to ask how have they obtained that consent, and can they evidence that consent was provided. And then once you as an organization have purchased that information and you reach out, so you might reach out to Gary Hibberd and say, Gary, we recently have taken your information from this source. They provided your details because you previously gave consent to be told about our service. We would love to keep in touch with you. Would you like us to do that? Now, some people are calling that as a double opt-in. I just call that good manners. So it's about being able to evidence from that direct marketing organization that they have obtained consent, and that you can evidence that you have that consent from them.
Okay. So a couple of questions around right to be forgotten, and I'm conscious of the time, but these two questions, one close to my heart. It says the right to be forgotten, does this include backup images, where obviously it's difficult to do that? And the second one is the right to be forgotten. If somebody owes you money and it's a financial debt, can they claim the right to have that to be forgotten?
Okay. Yeah, again, two fairly simple answers, to be honest. When it comes to backup, I would always, again, advise people to look at what their backup lifecycle looks like. Backup is slightly different to archiving, but certainly on a backup, when people say, well, do we have to go back to the backups and then remove them from backups? I would simply say that what GDPR is talking about is you make every step possible to remove them from your systems. You need to keep a record that you've removed them from their systems as well. But with backups, eventually they will be overwritten anyway. So they will, if your life cycle is that within a month's time that data will be erased, then you can, again, when somebody asks for the right to be forgotten, you can go back to them and say every effort has been made to remove you from our systems, and I think that's perfectly acceptable. Backups is an interesting area, and that technology and that ability may evolve. But again, we will learn some of these things as we go through GDPR. But I simply say, look, backups is almost a step too far for us to think about right now. My question to many people is, would you be able to enact the right to be forgotten on your live systems? Forget your backups for a moment. Let's just talk about your live systems. Let's deal with that issue first, and then we'll talk about backups later. But I think backups is a fairly easy story to be able to cover. In terms of the debt, no, you would have a legitimate interest for keeping that information. They can't write to you and say, we would like you to forget about the debt that we owe, because you have a legitimate interest. And that could be for many reasons. There could be a fraud reason there. So that could be the right, because your right to be forgotten really comes down to consent. So you're depending upon what you're holding that information for. If it was for the enactment of a contract, in actual fact, you can say, well, we're not going to. You can't enact your right to be forgotten because it's not under consent. But also, more importantly, we have a right to hold your information until that debt is cleared from a contractual perspective.
Okay. Somebody makes the point, asks the question, when did marketeers ever have manners? But I think that's a whole other webinar, I think. Somebody's asked the question about cold calling. So I guess and Michelle, I hope I'm reading right, that under GDPR, is cold calling now forbidden, if you like?
No, again, when we're talking about cold calling here, this is a whole different webinar. You are really talking about PECA. You are talking about the privacy and electronic communication regulations and a whole other set of regulations behind that, which talk about how you can communicate with people and cold calling and such. So yeah, that might sound like a bit of a get out, but genuinely GDPR doesn't really talk about cold calling in that strictest sense. It doesn't say you can't do cold calling. It just simply says for direct marketing, it may be a legitimate interest. So how you market to them is, whether that's cold calling or something else, is under a different regulation.
Okay, I'm just going to take two more questions. There's a lot more, and I think what we'll do is post the webinar. We're going to put together, an answer to all these questions, because I think they are really interesting. But just one of the last questions is on right to be forgotten, and it's around employees. So do employees have the right to be forgotten?
Again, they can, under the fact that you have a contract in place with them. It would be unreasonable for them to ask for the right to be forgotten whilst they work for you. So you could state, no, there's a contract in place. We have to keep this information for your interests as well as ours. I would always suggest that there is a period after which time they could contact you and say, I have a right to be forgotten, because you would have to argue why you're holding on to their data. Most organizations will stipulate that they will hold on to someone's data for 7 years past, or 5 years plus 2 after somebody has left an organization. So they'll hold it for 7. But if you worked for somebody 10 or 15 years ago, theoretically you could contact them and say, why, I'd like to have all the information you hold on me, and hopefully they should say we don't hold anything on you. But if they did, you could then say, I don't understand why you're holding that information. I would like you to remove it. Okay,
very good. And just the last question, and a few people have asked it. It's around the data protection officer. Can that be somebody outside of the company?
It can, yes, you can. You can absolutely have a outsourced data protection officer. A blatant plug for us. That's kind of things that we do. We've been doing that for the last 10 years. So we've been offering virtual security officers for organizations who can't afford a full-time security officer. And when GDPR came along and actually said you can outsource the role of a DPO, I almost fired my marketing manager and said, great, we've got a perfect opportunity here. It's you know, this is exactly what we've been doing for the last 10 years. So you absolutely can. You just need to find a good DPO, somebody, and invest in them and make sure that they understand your organization and that they are a good fit for you.
Okay. Now I apologize. I know there are more questions coming in, but I'm just conscious we've run out of time and we have to let Gary go. But what we're going to do, we're going to find a way to answer all these questions, and we'll communicate all of these answers with you, you know, in the very near future. So again, it's thanks to Gary from myself and Tara. Thanks to all of you who came on the call and made it so interesting with your questions. As I say, it's been most interesting, and I think we're going to be hearing a lot more of this between now and May. So thank you all, and goodbye from me.
Thank you very much for your time. Thank you all.